Guten Tag, SandwichGOPO. Ich heiße Frau Thorson, and today we are going to be talking about the Eine Amendment, the First Amendment of the U.S. Constitution, and how it relates to public policy. So let's get started. So what exactly are civil liberties? Because a lot of people get civil liberties and civil rights confused. Well, that's why we're going to wait till Chapter 5 to talk about civil rights. Civil liberties is just what we're focusing on this chapter, and it is the constitutional protections against the government, which is basically the first 9 and the 14th Amendment. The Bill of Rights are the first 10 amendments of the United States, the 10th one being rights for the states, rights reserved for the states. But the first 9 are basically the civil liberties that are given to protect citizens, to protect the populace. To my left, you are going to see the first 10 amendments of the United States, the Bill of Rights, and the order they came in. If you notice up top, it says when they were actually passed by Congress, which was September 25th, 1789, just 8 days actually, exactly after they ratified it. Remember, the reason that the Anti-Federalists approved the Constitution with just the preamble and the articles was because they were promised a Bill of Rights, and they got it Congress passed it 8 days after, and then a couple years later it actually got ratified by the states. I have given you a copy of the 27 amendments, so you can just refer to that rather than trying to look at this. To my left, again, you're going to see a chart, and in this chart you're seeing how certain court cases incorporated different civil liberties given in the Bill of Rights. You can see that this is actually the 1st through 9th Amendment. Again, the 10th Amendment is rights for the states, so the first 9 amendments are civil liberties. The only one of the first 9 amendments that hasn't actually been incorporated or decided on by a court case is the 3rd Amendment, which is the amendment that says we do not have to quarter soldiers in our house. We've never really had an issue with that, so that's never been the case. I have printed a copy of this for you as well, so you guys can look at it, but you could see some famous cases looking at this slide right now, ranging from Gitlow versus New York to Gideon versus Wainwright and Mapp versus Ohio. The Bill of Rights is in our U.S. Constitution, which is at the national level, but we have a federal system where we deal with the states. So how do the states relate to this? First of all, in Article 1, Section 9, it prohibits Congress from making certain laws. Congress shall make no law, ... according to certain areas. So that restricts the national government from being all-powerful, and this was incorporated with the court case Barron versus Baltimore in 1833. In addition, we've talked about this before, incorporation or a selective incorporation. Make sure you know these things because they tend to be on the test in May, whether in multiple choice form or in FRQ. Incorporation, they use the 14th Amendment to take any federal right in the Bill of Rights, any of our liberties given to us, and incorporate it at the state or local levels, that they have to follow what is said at the national level, which does give the national level a little bit more power over the states. The first court case to ever do this was Gitlow versus New York in 1925, where they incorporated First Amendment rights at the state level. Let's talk about the First Amendment, but before I do, here's an easy way to remember the 5 freedoms that are given in the First Amendment. I always remember them as RAPS, R-A-P-P-S, which stands for religion, assembly, petition, press, and speech. They're not necessarily in that order in the actual Constitution. However, you can remember this an easy way, R-A-P-P-S, so keep that in mind. All right, so the first one that the Founding Fathers decided that needed to be mentioned in the Constitution was freedom of religion. And little side note, surprisingly, a lot of people today assume, especially those that are on the right, that the reason they put freedom of religion first was because the Founding Fathers were very religious. On the contrary, they put freedom of religion first because they really weren't religious, and they wanted to make sure that people had the freedom to be religious or not to be. There are 2 parts to the freedom of religion right, and the first one is the Establishment Clause. And what that says is that Congress may make no law respecting the establishment of religion, meaning the government cannot establish a religion as an official part of the state. It's that wall of separation between church and state, as Thomas Jefferson said. Now, this has been put into question. These liberties that we have are kind of vague, so people are going to question them throughout the years. And one of the most important cases that dealt with the Establishment Clause was Lemon versus Kurtzman in 1971, where they were deciding whether or not schools, private schools, should get money from the federal government, because public schools, obviously, those are paid by tax money, tax dollars, but the private schools are paid for by private funds, and now they were asking for public funds as well. Well, the government said, we can't really do that because of the fact that you're a private school, and that would go against the Establishment Clause, because if we give you money, it seems like we're establishing a religion because we're promoting whatever religion it is, in this case, Christianity. But Lemon versus Kurtzman questioned that idea, and the Supreme Court decided that in order to decide whether or not the government gives funding, public funding, to private or parochial schools, they have to take the Lemon test, which is a 3-part test. Number 1, they have to decide, is it secular in their purpose? So if I'm giving them money, is it not religious? So if they were giving them money, for instance, for math textbooks, that would be okay. Number 2, what their money is used for neither advances nor inhibits religion. So as long as it doesn't advance or inhibit it, it'll be fine. Again, you can look at it like the math textbooks. And number 3, there's no excessive government entanglement, basically meaning that it's kind of like a hands-off, wash our hands of this. Here's the money, do with what you need to do with it, kind of like what we talked about with block grants. There were several more court cases that looked into the Establishment Clause because it, like I said, is very vague, so civil liberties is never black and white. So what are some other things that were questioned? One other thing in 2002 in the court case Zellman versus Simmons-Harris was the fact that they were looking at if school vouchers were constitutional or not. School vouchers is just a way, if someone's disappointed in a public school, they can transfer to a different school without having to move, whether it's public or parochial. And in this case, they're wondering, does it violate the Establishment Clause? Because if you're sending someone, if the government's giving a voucher to someone to go to a parochial school, is that unconstitutional? Does that violate the Establishment Clause? And it doesn't, just because it's kind of going along with the Lemon test, where it doesn't really violate. It's not really a matter of promoting religion. It's for secular reasons. Number 2, Engel versus Vitale, that was in 1962, and it asked the question, is school prayer unconstitutional? And the answer is yes. It does violate the Establishment Clause to have prayer in public schools. So anytime you're doing the pledge in the morning and you're doing the moment of silence, remember that is up to you what you do, but the school cannot tell you that it's time for prayer. The next question we're going to look at is, are displays of the 10 Commandments unconstitutional? The 10 Commandments coming from Jewish and Christian religions. And it is considered unconstitutional to display those. Usually the places that were being questioned were courthouses or government buildings that would have 10 Commandments in front of them. And they said that does violate the Establishment Clause, because if you have them there in a government area, it's as if you're establishing that these are the rules to follow from this particular religion. The second part of the First Amendment's freedom of religion liberty that we get is the Free Exercise Clause. And what that says is that it prohibits the government from interfering with any type of religious activity. Now, there are some exceptions to this rule. Some religious practices are in conflict with other rights, and they can be denied or punished. For instance, and this has really actually been most questioned by the Native Americans' religion, where they practice religion on specific lands they find sacred, and part of that practice is ingesting or intaking or smoking the illegal drug peyote. So in 1988, there was a court case, the Employment Division versus Smith, where 2 Native American workers were fired from their jobs because they came to work high from practicing their religion, and they felt that it was constitutional for them to do that. They were believed it was part of the Free Exercise Clause if the government couldn't stop them from practicing this. And the government actually said, no, that is unconstitutional. to smoke drugs, even though I know it's part of the free exercise clause. It is your right to perform a religious practice and we can't interfere with it, but it goes against the other laws, so you can't practice that. Well, many people got outraged by this, so in 1993, Bill Clinton passed the Religious Freedom Restoration Act, which basically said they would look at it in a case-by-case scenario. Specifically, again, this was, even though this is for all religions, it's a universal law, it was really meant for the Native Americans' religion. The next freedom we're going to talk about is freedom of expression, which is basically freedom of speech and freedom of press rolled into one. First, we're going to talk about freedom of press. There's this idea of prior restraint where a government prevents materials from being published or censored. Lots of governments do that. Our government is not allowed to. We have the freedom of press. It is considered unconstitutional. But it's not all black and white, as I've told you before. There are many gray areas, many areas that are questioned, and this has been questioned, where the government actually can have prior restraint, meaning stop something before it is published. When was this decided? In 1931 in the court case Neer versus Minnesota, that yes, prior restraint can be used only in cases of wartime. It's just a matter of national security. That's how they're focusing on that. That if it hurts or would interfere with our national security, then they do have the right in wartime to stop things from being published. But one may be punished after something is published. They might publish it, and there's different ways that, and different reasons as to why somebody could be punished afterwards for what they have published. What about freedom of speech and public order? What if someone says a certain thing and it basically causes chaos? Well, that actually is considered unconstitutional. In Schenck versus the United States in 1919, they said that if someone says something that promotes or presents a clear and present danger, then they can get arrested, and it's against any law. So it is constitutional to arrest somebody if they say something that might present a clear and present danger. For instance, bomb on an airplane or fire in a movie theater. In 1969 in Brandenburg versus Ohio, there was always a question of, is it okay to advocate the overthrow of a government? And before, it was considered illegal to advocate the overthrow of a government. But now it is considered permissible to say that it's okay to have a violent overthrow of a government. That is freedom of speech, as long as it's an abstract, not necessarily inciting anyone to actually do it. So if I were to say, I want to overthrow the government violently, that's okay. But if I were to say, let's go overthrow the government and here's the plans and here's how we're going to do it, that is considered illegal. Now you must understand that in public places, speech is generally protected, but it's not on private property. Why? Because you own it, and if you don't like what's being said, you can have that person get arrested. Basically, you could use trespassing as that. There are many gray areas to freedom of press. One question that's been asked as of recent: is extensive press coverage of certain cases like the O.J. Simpson case or the Martha Stewart case permissible? Is it allowed? And the court says yes, it is allowed. The trial should be known to the public and should be open to the public. Now, some of the information that the press gives, some of their own information, may not be protected if it might do something to hurt the case, but it is allowed to be seen by the public, or like the Drew Peterson case that just happened recently. Some states do provide shield laws to protect their reporters that gives reporters in that states even more freedom of the press. When it comes to freedom of expression and obscenity, it's very vague. It is a very gray area. Even Justice Potter Stewart said, I know it when I see it. So it's basically a case-by-case scenario. The closest thing that we've really had to deciding what would be obscene or not would be this case in 1973 of Miller versus California. It stated that materials were considered obscene if three things happened. Number one, it appeals to the prurient interest of sex, like you have a obsession with it. Number two, that would be incredibly offensive. Number two, it shows patently offensive sexual conduct. Or number three, it lacks any serious literary, artistic, political, or scientific value. So even those three explanations are vague. So as the court has actually made a decision on obscenity, it really still has been vague. So because of that, decisions on obscenity typically have been based on the local community and what they decide is obscene or not. You probably might not have realized this, but it is actually unconstitutional to say bad things about somebody else, especially if you're completely lying and making things up. So it's just a matter of if they actually take you to court for it or not. Now, what are the two types of defamatory language, I guess you could say, that could get you into trouble? First is libel. Libel is the publication of false or malicious statements that could defame a person's name or damage their reputation. Slander is the exact same thing, except it's spoken. So how do you remember the difference between the two? Slander, spoken, both start with an S. What court case had to deal with this? That would be New York Times versus Sullivan in 1964. That said that statements about public officials are libelous if they are made with a reckless regard to the truth. So if they make, you can say anything you really want about people as long as it's not all lies, all complete lies. Now, in for private individuals not looking at public figures like politicians, they have lower standards to meet with libel, to win libel lawsuits. So if you're saying bad things about a private person, that would be easier to win a case than if you were a public figure. What did I just do there? Did I speak to you? You knew what I was saying. I was saying, hello, good job, you're A-okay. Well, don't ever do that in Brazil because that's basically like flipping them off. But that is called symbolic speech. It's nonverbal speech that gets a message across. That pretty much is also protected by the First Amendment freedom of speech clause. You are allowed to speak how you want, even if it is nonverbal. Now, what have there been cases about? Well, we've got Tinker versus Des Moines, CUSD, where that was wearing armbands in school as a sign of freedom of speech to go against the war. But the other big one that was of recent, 1987, was Texas versus Johnson, where it was asking if flag burning was constitutional. And yes, it is. It is a symbol of freedom of speech. It is symbolic speech, burning a flag in protest, showing that you are upset with this country. Is it unpopular? Absolutely. Many people think it is wrong. But the first, you need to understand the civil rights, or the civil liberties, excuse me, that are listed in the Bill of Rights aren't meant to protect popular things. They're meant to protect unpopular things, because no one really cares about protecting popular things because most people like it. This is meant to protect the things that are unpopular. Probably the most restricted form of speech is commercial speech, which is basically any type of speech in advertising. Generally, it is restricted by the Federal Trade Commission because they regulate and decide what can and can't be put on television. And it usually tends to be with broadcasting any type of political or governmental advertisement. So if there is, they make really strict regulations on that. In 1996, the government actually made this act called the Commercial Decency Act, where basically anything that they felt was lewd or sexual or inappropriate, they would only allow to be aired between 10 p.m. and 6 a.m. So the Playboy Entertainment Group in 2000 sued the United States government, saying that by doing this, it restricted their right to freedom of speech by forcing them to block their channel for all of that time. And it was a very close vote. It was a 5-4 vote, but they did go in favor of the Playboy Entertainment Group, saying that regulation has to be narrowly tailored to promote government interests. It had to be more about the government, not necessarily about something lewd or obscene. One of the freedoms that's given in the First Amendment that people don't really think about, but is very important, is the freedom to assembly. This is the idea that you can gather in a place without the government interfering. Now, there are some restrictions to it. You really do have to abide by certain laws that are already in place, like fire codes, and you have to apply for a permit to do this. As long as you're not instilling violence in these public places or doing something, speaking in a clear and present danger, you're okay. That's why, for instance, with the Tea Party movements, they typically aren't ever dispersed or people aren't arrested by them because they tend to get permits. Whereas the Occupy Wall Street people who did get arrested, did not have permits for what they were doing. So that's one of the reasons why they did get arrested in situations like that. Another group that there was a major case about with the freedom of assembly was a neo-Nazi group that marched in Skokie, Illinois. If you don't know much about Skokie, it is one of the predominantly Jewish communities in the state of Illinois. So they were marching in a public place there, basically saying absurd, racist things towards Jews. They got arrested for it, and they took it to court to say that it was their right to freedom of assembly and freedom of speech and their First Amendment rights. The ACLU, the American Civil Liberties Union, an interest group, they actually reluctantly defended the neo-Nazi group because their job is to protect people's civil liberties, even if it is as unpopular as what these Nazis were saying. Again, the liberties of the First Amendment through the Ninth Amendment were to protect unpopular things, not necessarily popular things. There's also, because of the NAACP versus Alabama in 1958, they also said that people could join groups or association without the government stopping them, because the government, as we know, as you probably learned with the Cold War, could stop you or we're trying to make you register if you join certain groups. And this one is saying, no, you can't stop that. That's part of freedom of assembly. It's similar to that with freedom of association. So that is it for the First Amendment. I am signing out. Have a good evening. Thorson out. Port.